Hi Nafis, I didn't see you. I thought even you didn't join the session. So let's start. Right, Nafis. So in the last class, we stopped at question number 20. Can you start answering 21 and 22? So then we can discuss. Okay. All right, let's discuss the question number 21. DDD PLC requested a meeting with the auditor of a company that it wanted to take over in order to discuss the company's finances. In the meeting, the senior partner of audit firm stated that the target company's latest accounts can be relied upon. The takeover took place and it was discovered that the accounts of the target company understated the debts by 10 million pounds. Okay. So what happens here? So DDLCPC is requesting a meeting with the auditor. Okay, so they wanted to buy a company, a takeover. So to discuss company finances, they are arranging a meeting. So the senior partner of the audit firm stated that the target company's latest accounts can be relied upon. So they're telling that she's giving the reliance to purchase this company. But after purchasing this, they have understated the debts by 10 million. So it is something really crucial. So they're asking which of the following describes the legal position of the audit firm. So what is the legal status? So can we complain or can we make a case against the senior auditor or not? Okay, so let's see. The auditor does not owe duty of care to PLC because it was not a client of the firm. Right. Can you say that? No, right? Because see, because of his decision or because of his information only, we have made this decision to purchase it, isn't it? So it doesn't mean that he can't owe the duty, he is owing a duty. Okay. So second situation also it mentions that the auditor does not owe the duty. No, he owes a duty. Okay. So because of his decision only, we are losing this 10 million pounds because he have understated the debts by 10 million pounds. So the auditor owes a duty, yes, he is owing a duty of care of the statement of the senior partner. let's see. Then let's see the other option and come back to the part. The auditor's duty of care. Yes, both the instances is owing the duty of care because it is his duty to care his client. Okay, so they could have foreseen that the accounts may be used in a takeover. So what should be the correct answers? Now I told you he does owes a duty. Okay, so he owes a duty. So in these two options, what would be the answer, Nafis? What did you think? What should be the reason? Because of what this statement is becoming a legal concern. Good. So this should be the answer, but I would also like to say, so in generally, if there is an auditor, he does not owe duty of care to the public. Okay, so make sure that you remember that. So generally, public auditor is not responsible for public. So what happens is, in this case, the statement by the senior partner is sufficient enough. Okay, is sufficient enough to create some duty of care. So because of the statement only, this auditor becomes responsible for this. Okay, because auditor will also audit based on the information supplied to him. So that's why we used to say auditor is not generally responsible for the public. But in this case, he is giving a statement on it. So then he is having sufficient amount of care that he have to take place. Right. 22nd one, let's discuss it together. What is the statutory minimum notice period that an employee with 12 years of service have to give the employer when they wish to terminate their employment? If you are working 12 years, okay, the statutory minimum notice period for the employees, it's regardless of the number of years that you work, it should be 1 week. That is the statutory. No, this is they asking statutory minimum notice period. So the minimum notice period will be, it doesn't matter how long you work, it needs to be a week. It needs to be a week. Okay. So question number 22, sorry, 23, 24, and 25. Start doing, guys. I'll quickly plug my laptop to the charger. Right. Let's see the answers. Which type of consideration means the payment, has been provided where goods are delivered and payment is made on the same time? So if goods are delivered and payment is made on the same time means it is executed consideration. It is an executed consideration. So executed consideration means it occurs at the present time that the goods are delivered and paid. So it's happening on time itself. Okay. What do you mean by executory consideration? So that is a promise that you are giving to buy goods. Okay. The promise that you are giving to buy goods at a future date. So past consideration means that occurs before the contract is made, right? So like I would also like to say in this terms to you. Okay. So executory consideration means promise to pay in future. So this is the past consideration means this happens before the contract. Good. So how will Bryce, whatever, email to Lucy be treated under contract law? Let's see. L sent an email to B that asked, will you sell your car to me? So he's asking, will you sell your car to me? So B sent an email replying stated that the price is 2000 pounds or euros. Sorry, pounds, right? 2000 pounds. So they're asking, it is an offer, it is an invitation to treat as a supply of invitation, it's an invitation to tender. What does it means? Is it an offer? No, it is not an offer. It is just informing certain things that he have requested, right? So he's asking how much you are selling for. So it is not an invitation to trade, it is a supply of information. So he's requesting information, so that information has been granted. Right. Then in relation to company meetings, who is a proxy? So it's easy, right? A person who is appointed by the shareholder to attend the meeting and vote on behalf of him. So that is what a proxy means. A proxy means you are now let's assume you are unable to attend the company's meeting, so you are giving rights to someone to act on behalf of him. Okay. Then can you try the next three? 26, 27, and 28? So let's discuss one ground for a creditor to apply compulsory liquidation. If you want to apply for a compulsory liquidation of a company, that they are owed a minimum amount. So there is a minimum amount that you can go for compulsory liquidation. They have issued a written demand for payment of what is owed, and the company fails to repay the debt and offer reasonable security for it within 21 days. They're asking what is the minimum amount of debt owed the company for his procedure to apply. So if a company needs this procedure to apply, they need at least to show 750 pounds as the minimum amount of debt that they are owing. Okay. So otherwise they can't apply this rule. So it should be minimum 750. Right. So everyone got the answer correct there. Good. So which of the following statements concerning consideration is correct? So always think guys, consideration needs to be sufficient. Okay. Consideration needs to be sufficient enough, not adequate, or consideration from each party must be equal value. No, it is not. A consideration always needs to be sufficient. Okay. Then, which of the following is the name given to companies that are created by directors of insolvent companies? So, they ask you which is the name given to the companies created by directors of insolvent companies in order to continue the business legally, that is unicorn companies or phoenix companies or dragon companies. What is your answer, guys? It is known as phoenix company. It is known as what? Phoenix companies. This is the name that they are giving. Right. So let's do these two and we'll jump into a case question, a task question no, and then come back and do the rest of the MCQs. Try these two guys, 29 and 30th. Guys, meanwhile, I'm asking, is it possible for you all to join tomorrow at the same time so that we can sum up all our sessions? Is it possible, guys? I mean, the morning around 8:30, because of course next week it would not be possible for us to do it. So we got only one more session, so we need to cover it. Or else on a Thursday, I can possible for Yami. How about Nafis? Because I don't know whether others will join. I don't see others in this call today. If it's possible, I'll drop a chat in the group. Please respond to that, okay? Right. Done. So let's discuss which of the following will not cause a floating charge to crystallize. Okay, which of the following will not cause a floating charge to crystallize? Liquidation of the company will cause. Liquidation of company will cause a floating charge to crystallize. Okay. Sale of assets, the assets The charge in secured on, let's see what does it means. Cessation of the company's business, yes, it will cause. Appointment of a receiver by the charge, of course, yes. Now, sale of the assets which are secured on will not cause a floating charge because it's already secured. So it does not crystallize. So all the other three options causes the charge to crystallize. Okay, right. Which of the following is the remedy? So they're asking for the solution to the injured party in the event of breach of warranty. So if you are breaching your warranty, what is the remedy? So the treat the contract as discharged only, claim damages only, treat the contract as discharged and claim for damages. No. The remedy for warranty will be you can claim only for damages only. You can claim only for damages. Okay, cool. So let's answer. I think we did this last week. Did we do the second one? Yes, second one also we did it, I think. Oh, no, second one we didn't do. So let's do the second one. So what I will do is take this like this. But this is third one. And second one I can show it full. Right. So I will give you now there are only two questions. So maximum I'll give you for 8 minutes to read this and this. So within 8 minutes, we are going to discuss this. Read the scenario and exploit the answer. It's very important to understand the scenario and exploiting the answer. Okay, let's discuss. I think, oh, you need time. If you need time, I can give time. But if you guys are done, then we can discuss. Nafis, how about you? If you need time, I can give. Okay. So Brian is the manager of a distribution warehouse that supplies number of do-it-yourself stores. Okay. So following the introduction of a new computerized stock record system, after introducing a computerized stock system, Brian is dismissed because he is unable to adapt to new working practices. So he is unable to adapt for new working practices. No warnings were given and no disciplinary action was taken before his dismissal. Brian has worked for the company for last 15 years. As a result of the reorganization, John is also dismissed because of his involvement in trade union activities. So he has worked in a company for 9 months. So the questions are, which of the following are available remedies for unfair dismissal? So if you are unfairly dismissed, guys, okay, you can request for a compensation from your employer because you're unfairly dismissed. So then he need to compensate you for your losses. Whatever the loss that you are making, then he's supposed to bear it. Or re-engagement. He can engage you in he can ask you to work, okay, but it's a different job he needs to give under the same employer. So I have given these definitions in a previous thing, right? Then reinstatements mean what? He can ask to return to the job, the same job, okay? So the same job, whatever he does, uh, without any break or continuity of his employment. Okay, so he can join the work as it is. So the three remedies that is for unfair dismissal is compensation, re-engagement, and reinstatement. Right. So now they are asking us identify which of the following dismissals. So when you're dismissing an employee, which applies to Brian's case and John's case. So in the fact of Brian's case, what sort of a dismissal it is? Is it a redundancy? No, redundancy means you make a payment. Okay, because redundancy means actually, now let's say I'm going to close down my operations. So I don't have enough jobs or the relevant jobs to match your skill. So then I can make you redundant. Okay, so I can give you a redundant payment and send you home. So it is not redundancy in the case of Brian, actually. Is it an unfair dismissal? I can't call it as an unfair dismissal because Brian has been, dismissed in a wrongful way. Why he has been dismissed in a wrongful way? Because no, he is unable to adapt to the new work practices. That's one point. So that is not creating a reason for redundancy, anyways. Okay. So, as I told you, redundancy occurs when a person's skills is no longer required. So that's where a redundancy is getting started or getting giving birth. So what you need to understand in this concerns, in this situation is the capability is a fair reason for dismissal. Okay, but this dismissal is unfair because you are suddenly bringing up the system and asking him to leave is unfair. Okay, it is not being unfair because he's not adapting to it. That is important. And here the case is he is getting dismissed without giving a sufficient notice period. Do you understand that? So Brian is getting dismissed without giving a notice period. So that's the issue here. That's why we call it as wrongful. Then in the case of Joan, it is unfair. It's an unfair dismissal. So as he joined the trade union, you can't just whack him out of the business. So that's the scenario there. So if you, I mean, hopefully, compared to other task questions, if you get questions on these areas, it would be pretty much easy for to handle in my concerns. So make full marks out of it. Right. Let's do the question number 3. Can you start doing it? Take your time. This needs little time. So I'll give you 10 minutes. I'm giving 10 minutes as the minimum. So you can read and try to get the answers. If you need more time, I can give. Shall we discuss? So, Matt is in the process of setting up an IT business as a private limited company. So, you're setting up a business as a private limited company. He has been told that in order to register the company, he should submit appropriate articles of association, okay, and a memorandum of association. So he need to submit articles of association and memorandum of association. He also thinks that because there is an existing similar or local business called Netscape Pty Limited, it would be a good idea to call his new company as Netscope Limited based on the chance that he could transfer some of its new business to his new company. Right. So there is an existing business he's already running in the name of Netscape, but he is going to start it as Netscope. Okay. So see the first question. Which of the following is contained within company's memorandum of association? So they're asking what are the details which is under memorandum of association. Details of class rights, name of the subscribers of the company, rules governing and conduct of meetings, power of directors. All these things will be recorded in an articles of association, and then name of the subscribers to the company will be recorded at memorandum of association. Okay, right. Then which of the following statements concerning Matt's company's articles of association is correct? They're asking for the correct statement. Okay. Matt company will not be registered until he submits articles of association. The asking will not be registered until he submits the articles of association. Met company may trade while he finalizes its articles of association. If Met does not submit articles of association, then registrar will incorporate the company with model articles for a limited company. If BAT does not submit the articles of association, then registrar will cooperate the company with model articles for a private limited company. So what happens now? If you now what happens is, guys, you cannot start up the company without your articles of association. Okay. So like you need to provide them to their registrar, otherwise you can't register your business. So what happens is, in the event of that a delay in submissions of your article of association, a registrar will see whether you are submitting it or not, but you are trading as a limited company. So since you are trading as a limited company, so when I say limited liability company, I should say, so that type is the private limited company you are choosing to start. So you, if you did not submit the articles of association, then registrar will incorporate using the model articles for a private company. So that is the decision will be taken by the registrar, because you don't supply. So I'm gonna create it on model articles. Okay. So do you have model articles for limited company? guys. Right. Good. Always remember a company cannot start without articles being formed. Okay, so they can't like continue, they can't form the business or they can't trade it. Okay, so that's the reason why the registrar is using the other option. Right. Next, what advice you would give to Matt regards to his proposed company's name? So he's telling, no, this is the name he's proposing. The proposal is this, and this is an existing name. Let's see. He should use the name because it is not same as the existing company. He should use the name of the because there are no laws against using similar name to another company. He should use the name because he would be prevented to do so by common law. He should not use the name because it is unethical to do so. So, what is the advice you will give him? So, I would always advise him it is prevented to do in the common law because it will what happens. So when you're using the name, it confuses, right? It confuses now Netscope and Netscape, it will confuse, isn't it, for the other company. So by common law, what happens is you can't use or you should not use the name because in accordance with common law, it is prevented. And also, court may pass an injunction to you. Okay. And then the defendant company to change the name because they can say these guys are using somewhat similar to our company's name. Yes, it's not the same, but similar. So by common law, you can take off a case against this as well. Okay. Right. Let's go back to our MCQs and come back to the rest of the questions. Two more tasks is there. So we did up to 30, I think. Yeah. So can you try this for 31 to 34? Answer till 34. Okay. Right. The criminal division of Court of the Appeal normally hears appeals from which of the following courts? So, criminal division of the court appeal hears the things from Crown Court. Okay, so the criminal division is hearing things from Crown Court. So in the context of the legal system, what are rules of court? So rules of court means what? A form of delegated legislation, a parliamentary procedures followed in the formation of primary legislation, a handbook used by judges interpreting primary legislation, guidance given to judges when applying UK human rights legislation. Rules of court means it is a form of delegated legislation that allows the judiciary to control court procedure. Okay, so it gives control the court procedure. So in the legal system, rule of court means a form of delegated legislation. Right. A private limited company is distinguished from corporate forms by what end of its name? It is LTD, right? Private limited company. So we call it LTD. So LLP is used for public listed, sorry, PLC is used for public listed company and LLP for limited liability partnership. LLP is for limited liability partnership. So in relation to the payment of dividends, which is a distributable reserve. So this is an FA question. What is a distributable reserve, right? Capital redemption, revaluation reserve, retained earnings, share premium accounts. You always pay dividends using retained earnings. Okay. So you need to use retained earnings to pay dividends. You can't use any other reserves. All these other reserves are non-distributable. Okay. Only retained earnings is distributable reserve. Right. Answer these three now. Let's discuss which of the following will prevent a company from appointing an administrator. Which will prevent? They're asking which will stop. The company is currently unable to pay debts. So, if you are unable to pay debts, then you need to have an administrator. A resolution of floating charge holders with a majority of 75%. No. A receiver currently in office at the company. So if you have a receiver currently in the office, then why you are appointing an administrator? So this is what stops appointing an administrator. Okay, all the other things will cause them to appoint an administrator. So they're asking what will stop. So if someone is currently holding, then you don't want. Okay. So in relation to insider dealing, information that is made public is not classed as inside information. So whatever the information which is available for public is not classed as inside information because it's already given to the public. Which two of the following informations are, or which two of the following are information that is made public? The information which are published under the rules of regulated market, yes, that is one thing that how you can reach informations to the public. Then informations concerning public companies, no. Information communicated by the company's chairman, no. That is insider informations. Informations which are published in Gazette. So these are two modes how you will communicate the things or share information to the general public. Okay. Right. So 37th one, which two of the following must be included on an employee's statement of prescribed particulars given to them soon after they commence employment? So which two of the following must be included in an employee's statement of particulars? So what needs to be there? They need to give the entitlement to flexible working and details of pensions or pension schemes. It is important. Okay. The job title and the details of pension schemes are included on the statement. Okay. Mostly the other options are not. Yeah. The other options are not. Yes. This same. Sorry guys, my bad. This needs to be job title, right? I have highlighted here. The job titles and details of pension schemes needs to be here, not the flexible working hours. The statement is these two only needs to be there. The job title and the statements needs to be included in the statement. Okay. So it should be 1 and 4. Right. We'll do 38 together. Which party is not liable for pre-incorporation contract? So which party is not liable on a pre-incorporation contract? So the company is not liable in a pre-incorporation contract. Okay. Because they did not exist when the contract was formed. Because when you're forming the company, okay, so before you form the company, if you're having any contracts, the company is not liable. Okay, right. Then try these four. Right, the 39th one. After what continuous service does an employee eligible for redundancy payments? He needs to be there for 2 years. Then only he is eligible to get redundancy pay. Which two of the following parties are bound by company's constitution? So two parties is your company's shareholders and the company itself, not anyone else, because your company's constitution is for you and the company. So which two of the following are valid defenses to a charge bribery? Okay. So it's a valid defenses only they are asking. Right. Um, the person did not expect to make a profit. The person was exercising their function as a member of intelligence service. The person was exercising function as a member of armed forces. The person had reasonable grounds to their conduct. So the two valid things for a bribery case is, okay, the person was exercising their function as a member of intelligence services. Yes. Okay. Then if you are exercising function as an armed forces on activity services, yes. Because the only members of the armed forces or the intelligence services that are properly exercising their functions and have a defense to bribery charges. So they have a defense to bribery charges. Right. 42nd one. Which of the following is not a type of repudiatory breach of contract? Renunciation, incapacitation, excommunication, breach of condition. We didn't study something called excommunication. So that is not a type. That is a direct one. Right, last three. Try this. Right, let's discuss how an advertisement of goods for sale treated under contract law. So advertisements of goods for sale generally treated as an invitation to trade. In tort of negligence, what is the effect of eggshell rule, skull rule? Okay, the claimant is expected to take extra care. They are more prone to injury. The claimant is expected to have notified the defendant that they are at a high risk of injury. The defendant is expected to take the victim as they find them. The defendant expected to assume liabilities and foreseeable damage of the claimant if the claimant is especially vulnerable. So the Excel shell rule says you the defendant is expected to take the victim as they find them. Okay, that's a rule of Excel. So terms of business to business contract may include expulsion clauses limiting parties' liability for losses due to negligence. Which two of the following expulsions clauses are only valid if reasonable? So the reasonable thing, liability for death, liability for economy loss, liability for damage of a vehicle, liability for personal injury. So which two of the following are expulsion clauses for a only for a valid if reasonable? So economic loss can be valid if it is reasonable, but as well as the liability for the damage to a vehicle. It also seems to be an exclusion clauses, but the death and the personal injury are void. Is to avoid cases. It is not an expulsion for losses. These to avoid. Okay. Okay. That's all good. So we're done with our MCQ part. So we left with two more questions. So let's do the fourth one. Fourth one is little big. So read the question really well. So we share both of the screens like this. Okay. The other two questions are on the other side. So this is the full question that you need to attend. Let's discuss this question in 10 minutes or 5 to 7 minutes. So read it well and choose your answers. Are you done, guys? Shall we discuss? If you need time, I can give. We're middle of something, or like, if you want time, let me know. Okay. 5 years ago, Kim, Liz, and Meg formed ORB Limited. So they're housing a private limited company in which Kim and Liz each hold 40%, which means they are covering 80% of the shares, and the remaining 20% is owned by the Kim. So they are only directors. The objects of ORB contained in the articles are restricted to research. No, it is restricted to research, production and marketing, and environmentally friendly products. Okay. So in the course of research project, O Limited, K discovered a new highly powerful industrial cleaner. So K is discovering a new powerful cleaner, but unfortunately it is extremely toxic and not at all environmentally friendly. She persuaded L. Lees that Orb Limited should sell the new product and pay recently and the pair recently signed a contract with Z Limited to distribute it. The pair have started to market the product and the potential customers as well. Maintains the contract is contrary to the restrictions stated of O Limited's articles and is not binding on the company. Okay. So you are discovering a toxic thing, okay, but the articles is also maintained then it is restricted to research, production, and marketing environmentally friendly cleaning products, but this is in against that because it is not supporting environment friendly products. Right. So what is the statements describe the legal capacity of a registered company to contract? Okay. So let's see. A registered company may enter into lawful contract and cannot be restricted by the members. Okay. Then a registered company may enter into any lawful and unlawful contract. That sounds little weird, right? A registered company may enter into any lawful contract subject to any restriction placed on it by members. A registered company may enter into lawful contract subject to approval of the members. So the legal capacity of a contract would be when a registered company they can enter into any lawful contract, okay, which is subject to restrictions placed on by its members. So whatever the contract that you are abiding when you're forming your business, so then you can enter into such contracts and the contract should be lawful. You can't enter into unlawful contracts. Okay. So because the contractual capacity of a registered company is usually restricted and it may enter into any unlawful contract. Okay. I mean, not unlawful, sorry, any lawful contract only. So it is very important to make sure that you're not entering into any unlawful acts. Okay. And it is be within your restrictions and whatever you have decided upon. The second thing, can Z Limited enforce contract with O Limited? They're asking can or can't. No, the contract is ultra vires of the company. No, Kim and L do not have authority to enter the company into the contract. Yes, the principles of ultra vires does not apply to the companies. Yes, principle of ultra vires applies to the Company Act number 2006, protect third parties to ultra virus or ultra wires contract. So the thing is, they're telling that this contract is contrary, but they're asking, can you enforce its contract with O Limited? Yes, you can. Okay. So the principles of ultra-vires applies, but the Companies Act protects the third party to ultra-vires contract. So what you need to know from this is any contract entered. So like if you are entering into any contracts and if it is affected by restriction, that is known as ultra-vires. Okay. So any contract entered into that, if it is affected, okay, by such restrictions is known as ultra vires. And the other thing that you need to also know is the given validity of the Companies Act cannot question on the grounds of having the lacking legal capacity, okay, because the rule is very limited to effect the third parties are concerned anyways. Okay. So you can enforce the contract with the O Limited, but if third parties are impacting, then the negligence will be discussed later. But anyways, according to this principle, you can apply, but you need to make sure third parties of the buyers are protected. So it protects the third parties. So based on this, they can still enforce though the product is harmful to the environment but not for the users. Okay, so be aware on that part a bit. Then the third one, can Meg company Meg May sorry can Meg May stop Kim and Lee's marketing the new product to the potential customers? Can no count. So can he stop? Yes, because the shareholders owning 50% of the shares may apply to prevent the companies carrying out ultra-wise activities. Yes, because Kim and Liv have acted in breach of the statutory duties as directors. No, because Kim and Liz own sufficient voting rights of the company. No, because it is a matter of registrar of the companies to decide. In this situation, Meccan company for these guys, right? Because they have invested 80% of the company, isn't it? So they have the voting rights and they can make sure whatever the decision that they are passing to win. Okay. So that is within their scope. But Kim and Liz may have breached the duties as directors, but that does not mean Meg can prevent the marketing of the product. So they may breach, but it is not the reason to prevent the marketing of the product. And the court and the registrar will not get involved in these matters. Okay. So these matters is within registrars will not get into these matters ideally. So Meg can't stop having a contract with customers for Kim and Liz. Right. Try the fifth one. So then we can sum up this paper. Right. Martha is a finance director of a public listed chain of fashion stores. The company is finding it increasingly hard to pay its creditors as its sales are falling rapidly, and the point has been reached where Martha must decide to close the falling business down or battle on. Even though the business is unlikely to pull through, M joined on a revival store. Okay. It is experiencing some minor cash flow problems, and she's thinking about starting a members voluntary winding up to close the company as whole. So, which of the following is a criminal offense that M may commit if a member's voluntary winding up is commenced? Because she is making a false declaration, right? So, minor cash flows does not lead to I mean, a big problem to take care of solvent your business. You have to prove that your business is solvent. So this is you're making a false declaration on solvency. Okay, so it's an easy one. Identify whether Martha and M have any liability for fraud or wrongful trading under the Insolvent Act 1986. So Martha, fraud trading, wrongful trading, both offenses neither. She is not frauding, it is a wrongful trading. But M jointly owned, so is it fraud or wrongful? It's neither of the offense, right? Isn't it? So M, it is neither of the offense. Okay, guys. So let's take a small break and join by 11 o'clock. Okay. Be back by 11, and then we'll discuss few more other questions also. Okay. Hi guys, I hope you guys are back. So can you start answering this question? Start answering. We can discuss in 5 to 6 minutes again. Start answering. I will discuss in 5 minutes. Okay, boys, let's discuss. So, Fran, Gill, and Harry. In 2010, Gill and Harry formed a private limited company, a computer design limited, or computer design limited, to pursue the business of computer software design. They each took 100 shares in the company, and each of them became a director in a company. The articles of association of the company were drawn up to the date that Fran, a qualified lawyer, was to act as a company's solicitor for a period of 5 years at a salary of £10,000 per year. In 2015, Gill and Harry found that Fran had been working with rival software and has passed some secret research to the rival company. Okay. So, which two of the following statements are correct? So, they are asking us the correct statement. Okay. The articles of associations are enforceable by the company against the members? Yes. The articles of association is enforced to form against their members. Okay. The articles of association not enforceable against members? No. You're forming to enforce against your members. The articles of association bind the company to members in any capacity, not in any capacity. The articles of association do not bind the company to members in any other capacity. Okay. So, which two of the following statements are correct? Yet again, they are asking for the correct statement. Compuvia Designs Limit. Compuvia Designs Limited's articles of association can be altered by an ordinary resolution. Can you alter articles of association by ordinary resolutions? No. Computer articles of association can be altered by a special resolution. You can alter your articles of association by a special resolution. So you're learning something out of this. Then Fran can be removed from her position as a director by an ordinary resolution with special notice. Fran can be removed from her position as a director by a special resolution with special notice. So, when you are trying to remove a director, you can remove them from the position through an ordinary resolution with a special notice. You can do in this fashion. Okay, so these are the two correct statements to this, and they're asking the third one. Yet again, another two correct statements on this. Fran cannot rely on articles of association for her to remain as the company's solicitor. Okay. Then Fran can rely on articles of association for her remain as a company's solicitor. So Fran cannot rely on the articles of association. So if she wants to remain as the company's solicitor, because she need to be independent. She can't be rely on the things on articles of association. Then Gill and Harry cannot remove Fran from her role of company's director, and Gill and Harry can remove the Fran from her company's director. So Gill and Harry have the right, or they have the power to remove Fran from the role of company's director is the correct statement. So these are the powers of directors and these things. So this is an easy one to refresh of things what we have studied. Right. Can you try this question now? The king limited. Drop your answers when you are done. All right, let's discuss this question. King Limited is a property development company. Although there are five members of its director board, the actual day-to-day running of the business is left to one of them. Okay, so that is Lex, who simply reports back to the board on the business, and he has transacted. Lex refers to himself as the managing director of King Limited, although he has never been officially appointed as such. 6 months ago, Lex entered into a contract on King's Limited behalf with NAT to produce plans for the redevelopment of a particular site it hoped to acquire. However, King Limited did not acquire the site, and due to its current precarious financial position, the board of directors have refused to pay NAT, claiming that Lex did not have necessary authority to enter into contract with him. Likely to be. Let's see what happens. Okay. So, which of the following statement best describes the authority of directors to bind a company in contract? An authority is vested in board of directors collectively. The authority vests in membership, and directors must seek authority by ordinary resolution of members. Authority vests in membership. The directors must seek special authority from members. Individual directors have authority to make contracts and that they believe are in the company's best interest. Guys, you should know one thing. When things are entered into a contract, okay, the first thing is it doesn't mean that who now they are acting on behalf of the company. Okay, so the authority is vesting collectively. The authority is vesting collectively to the directors because he is trying to engage in this into contract to the best interest of his business. So entire board of directors would be collectively responsible for that. Okay, because they have given the business to him and he's the guy who is making decisions and everything. Yes. Okay, but he's not officially appointed. That's something else. But anyways, he's representing the organization. He did not represent, okay, someone else. So the power to manage the business of a company to its board of directors needs to be collectively owned. Okay, although the contracts they have made on behalf of the company by a person acting under its authority, so he's have implied or express authority. So you have to be very careful in choosing those things. So remember from the situation, now he is acting on behalf of the company anyways. His internal powers are limited, yes, but still he's representing the company, so entire board is responsible for that. Then, which of the following statement best describes Lex's authority to enter into contracts? Okay. So Lex has express authority, Lex has implied authority, Lex has apparent authority, Lex has no authority, Lex has what? Apparent authority, okay, due to being held out as a managing director. He's held outright. He's not having any express or implied, he's having apparent authority. Because the board of the king is permitted Lex to act as a managing director. He's just acting, but he has even used the title. The board, uh, I mean, he's representing Kings Limited as a managing director when he's entering into transaction, but he's not officially appointed in within the business, but that is how he is making the business. Okay, so consequently, the authority that he can enter into contracts, it is within the scope of the managing directors. Okay, so actually the Lex is having apparent authority due to being held out as a managing director. Okay. Then in relation to the contract with NAT, which of the following statement is correct? So they're having a contract with NAT. So Lex is personally liable under the contract. King is liable under the contract. I mean the King Limited, okay? Lex and King Limited are jointly and severally liable to the contract. No one is liable under the contract since it is void. I told you he is representing the King Limiteds. Okay. So it needs to apply the entire board, isn't it? So at this point also, the board is collectively responsible, which means he's acting on behalf of the company. So entire King Limited is liable under the contract. Okay. So hope you learned something out of it. Yes, it can be things that what we not actually thinking this should be the case. But when you think from a deep aspect, that would be the right scenario to do, right? Because you are asking me to run the company and you are just enjoying your meals. And when things goes wrong, you are blaming me. But when things goes good, you are taking the joy and you're being happy. So it's unfair from the person who is taking up the risk and acting on behalf, right? So, anyways, now this is a legal structure. Company is a legal structure. So if we are appointing someone, he is representing the company, not himself. So if it is before the formation of the company, then that prospective person is liable for it. After the formation of the company, then the company is becoming liable. Okay. So guys, let's sum up for the day with this. And are you guys available tomorrow morning? So that would be our last session. Or else, because next week, I think all our sessions are starting, so we can't do a morning hour session next week. So are you both free tomorrow? Or I just drop a message in the group. I mean, it's possible. Yeah, we can start at 9 a.m. It's not an issue. Okay, so then we'll fix it for 9 a.m. then. Is it okay with Yamin? Guys, I'll just drop a message, just acknowledge it, okay, in the group. Okay, guys. Okay, guys, then. Bye. I see y'all.